Generally, these are important components of getting your affairs in order. Often we avoid discussing things that make us feel uncomfortable, but an important initial planning step is getting your advance directives in place. We know that with a progressive disease like dementia, verbal and thinking skills will deteriorate. A living will allows your person's wishes to be carried out for when that person is no longer able to articulate them. Complete advance directives are documents that communicate healthcare wishes when a person is no longer able to make those kinds of decisions. A complete durable financial power of attorney appoints someone needed in order to handle financial and legal decisions. Whereas a complete estate planning really encompasses everything from wills, trusts, and funeral arrangements. Advance directives can vary depending on the state where you live. In Arizona, we recognize a durable healthcare power of attorney that appoints a representative and alternates to make healthcare decisions for you. A durable mental health care power of attorney appoints a representative to make mental health decisions and authorizes admission to a behavioral health facility. Many people say they've never had mental health problems. They don't need to complete that portion. But we really encourage people to complete the full packet because we know that with a progressive neurological disease like dementia, often emotional and behavioral symptoms present and behavioral health treatment is needed. A living will expresses wishes about medical treatment at end of life. One family whose mother had end-stage dementia decided not to aggressively treat a newly diagnosed cancer. A pre-hospital medical care directive, a do not resuscitate or DNR, is printed on orange paper. It directs emergency personnel not to resuscitate. In the event of cardiac or respiratory arrest, it directs withholding of cardiopulmonary resuscitation, or CPR, by emergency medical technicians and hospital emergency staff. We recommend that you keep that in a place where emergency medical staff will see it, like on your refrigerator. A person with end-stage dementia may or may not want to be resuscitated if a cardiac event were to occur. So in getting your affairs in order, it's very important to have a primary and backup decision maker or agent. Advance directives and durable financial power of attorney can be done independently by completing and signing those pre-printed forms. Or you might complete them with the assistance of an elder law attorney. Advance directives can be notarized or witnessed by one non-family member. But keep in mind that a durable financial power of attorney requires notarization and to be witnessed. Each state has different laws on advance directives. A healthcare directive prepared in another state is valid in Arizona if it was valid in the place where it was implemented, as long as it doesn't conflict with current state laws. If there's more than one healthcare directive and they are inconsistent, the most recent directive is deemed to represent the wishes of the patient. Also consider that the person with dementia, if they're your agent, they may no longer be capable of acting on your behalf. Look for healthcare directive sample documents in your state. In Arizona, we have them located on the Arizona Attorney General Life Care Planning Packet on the website, Advance Directives Registry through the Arizona Secretary of State. If advance directives are not completed and the person with dementia cannot make informed decisions, Arizona law allows for a surrogate to make most healthcare decisions. Surrogates are assigned in the following order: the spouse, a majority of adult children, parent, domestic partner, and so on. Surrogates cannot remove feeding tubes or IV hydration, nor can they admit somebody to an inpatient mental health treatment facility. A guardianship or conservatorship may be needed if medical and financial powers of attorney are not in place, or if the individual is uncooperative in allowing the powers of attorney to make decisions, or with significant family discord. Court procedures where a judge appoints a representative to make decisions occur. A guardian makes decisions about medical care, living arrangements, and all daily needs. It's equivalent to acting as someone's parent. A conservator solely manages finances. For example, if someone is capable of taking care of their daily needs and is cooperative, but is squandering money or being financially exploited, a conservatorship may be needed. You can file the petition paperwork with the court independently, but it is complex and typically requires the assistance of an elder law attorney, which can be quite costly. Once you've gone through the trouble to complete your advance directives, we tend to file them away and forget about them. Make sure to share this information with family or other people that you've appointed as representatives. Provide copies of the powers of attorney and living will. Keep copies of the legal documents and important papers in one protected place. And tell the appointed representatives where these documents can be found. Consider adding healthcare power of attorney copies to your medical record at your primary provider's office. We can't stress enough to have planning discussions early to be able to include the person with dementia. If you need more assistance, where do you want to be? How aggressive do you want medical care to be? Be cautious in making promises that may not be able to be kept. Often caregivers, family members, promise never to place their loved one in an assisted environment. But we know that with this disease, with dementia, as it progresses, the level of care rises, and keeping the person at home may not be possible, feasible, or even advisable. The safety of the person with dementia has to be the top priority.